And if at all they must be moved, we must be informed promptly that they are now being moved from one location to another. This has not been happening. And as such, it becomes very difficult for us to discharge the duty of representation. Your Honor, before you is an application supported by an affidavit. We would have most loved to reply to this application with a replying affidavit from each and every one of the respondents. But the same was not possible because we are frustrated of their location and access. Be as it may, we proceed as follows further. We join issue with the prosecution for the state and our colleagues for the victims that indeed this is a case of great public interest, both national and international. We join issue with them. And that, Your Honor, in the same strength, the respondents are suspects. They have not even been charged. Investigations are still ongoing. Such that, Your Honor, in these investigations, there is a possible outcome that the suspects can be set free, and the state could say that it does not find a way it can charge them. That is also a possible outcome. And also further investigations as they are going on, they might reveal other people and not necessarily the people before the court for whatever investigations that are being done. That is why the state and our colleagues for the victims, in their submissions, throughout, they have only speculated and said they may interfere, they may do this and that. In their own submissions, they have left out an option that they may not, and that it is not guaranteed. There is nothing to demonstrate that there is guarantee of interference. Your Honor, the motion before you seeks to detain them for 90 days. But the same we find it to be a gross abuse of the process of court. The application before you is an abuse of the powers of this court and any other court for the following reasons. The state exhausted its time for investigations that it had been given in Malindi, as seen in the miscellaneous number 41 of 2023. And in their own choice, they did not go before the court to seek for an extension of time. There was no such an application. There was no application seeking the extension of time. But they sought to close the miscellaneous file. Your Honor, I pray that this court will have a benefit to see the proceedings of that day, whereby Your Honor, we will supply them. We will supply them. Whereby we requested the court, now that within that application, within that very application, they had sought and they were given the orders to detain them. We submitted that the orders of the court should not only apply in their favor only, but they should be seen to cut across. And for that reason, we requested for their release, just within that application, that they be released. And they be given favorable bond terms. But the state insisted that on their part, they simply wanted to close that file. Your Honor, the state knew, and even in this very application before you, they knew that they were still investigating. They knew that they were still investigating. And they knew that they will come here to tell this court that they still want to be allowed to investigate. Your Honor, in their full knowledge, they knew that since the charges they think they might charge them with are still on speculation, even then they are still under investigations whether they will be merited for such charges. It was premature to say that they have to come to a specialized court unless they were coming here to charge and not to seek extension of time. Any extension of time, Your Honor, did not require a specialized court whereby it is to their knowledge that they are still investigating. It should have been done in Malindi. To have the respondents released and then they arrest them immediately inside the very cells where they were holding them is a mockery of justice. That is where the gross abuse falls of the powers of court. And it is ridiculous to be rearrested inside a police cell. There was no release, contrary to the orders of court that set them free. There was no release. It was a continued detention. Your Honor, be as it may, we regret that the state is hiding material information touching on these investigations, which is very unfair. The state is hiding very material information. And that can only happen because there are people who are protecting their jobs. Or there are people who would not want to take responsibility. But in the interest of justice, as we have said that, this matter touches every one of us. This is a matter that touches every one of us. We are all aware, and the whole world is talking about it, that there are some dead bodies that have been exhumed somewhere. And the accusations being made about that. Can we ignore that? Your Honor, we should not ignore that. Not the defense, and not the prosecution, not the state. Let us all be collectively concerned as follows, Your Honor. Such that the truth can come out. And the only truth, we just want the truth. And for the sake of the truth, we are also offering pro bono services in this matter. This is not a matter that we are benefiting in any way, financially or for any favors. We just want the truth.
Your Honor, I'm constrained to say something with your permission. Yes. Counsel in his address indicated that he didn't have time to file replying affidavits because he didn't have time to speak to his clients. But in his address, he has said he wants to say the truth or reveal the truth. We are interested in knowing whether this truth is coming from the respondents in the form of instructions. And we are also interested in knowing whether that came this morning when they had opportunity to see them, because we think that if some information is going to be raised before this honorable court, it ought to have come by way of a replying affidavit. If counsel says it came this morning, then I'll sit down. But if he says he had this information from before, then the next question is, why is it in the form of an affidavit? Otherwise, it's just assertions from the bar. And the honorable court knows what to do with assertions from the bar.
Your Honor, my senior colleague, I'm sorry to say that he's being mischievous. Sorry to use that word. But he should let me first finish what I'm saying. He's only disturbed by information which I already shared with him in good faith and in the great interest of justice. Now he is disturbed that I want to speak.
You know,
He should give me a chance to finish.
It's a minute ago.
No, I'm saying he should give me a chance to finish what I'm saying. If he has any objections to make, he can make them in his response. But I am calling upon all of us that why don't we all just seek the truth of this thing?
Just a minute. When you say we are seeking the truth,
Yes, sir.
Maybe this is the concern of counsel. Are you now going to say that truth, or it's just a statement you are making that you all want to know the truth?
I am going to say it, and he's afraid because I've shared it with him.
Your Honor, I can't be afraid. I'm just concerned the way.
Then he should let me say it to others as I said it to him.
That's the problem, Your Honor. It is coming from the bar.
He should let me say it. I have not yet said it.
Factual allegations coming from the bar.
Now,
Yes.
let me.
Yes, I have not yet said it.
I just wanted that clarification.
Yes,
Report objection.
yes.
Now, let me report objection by Mr. Jan.
But Your Honor, I had not finished saying that what he wants to object.
Yes, sir.
Much obliged. I stand guided.
No, that is a clarification.
Yes, Your Honor.
You know, there's a difference in saying that we all want to know the truth, and now saying that truth as known. So that is the clarification that I need.
Yes.
You say now you want to say the truth,
Yes.
or have I misunderstood you?
You've not misunderstood me. His concern was whether I'm receiving this information from my client and how. That is how I understood him. And when.
So let me simplify what I'm saying.
Yes.
Are you just making a statement that in the interest of justice, we all want to know the truth?
Yes. Yes.
Or you want to state issues of thought?
Your Honor,
In the name of stating the truth of what happened.
I'm saying in the interest of justice and then proceeding to what has been happening in the process of this investigations.
Let me write. I will allow Mr. Karim to say what he wants to say. I don't know what you think of it. Then from there, we see what objective.
Yes. So, Your Honor, before this matter came into play now recently in the month of March, Your Honor, I wish to tell the court that there had been an earlier report raising such allegations against the first respondent sometime in the month of November 2022, whereby, Your Honor, a lady by the name Brenda Mwaura posted in her Facebook account and tagged DCI Kenya. That was in November last year. Posted in November last year and tagged DCI Kenya. She posted the following words. I want to read them.
Yes,
I was expecting Mr. Jami and Steve. Because the question you raised is not, we are getting Mr. Karim testify, giving evidence, contrary to what is on record.
Your Honor,
So that's the objection.
Your Honor, I first started by explaining why today we are constrained to proceed in such a manner and the kind of rights of the respondents that have been denied by the police and which the respondents believe are deliberate so as to conceal that what is already there.
I'm afraid that at this point I would not sustain this. State. I believe that that's the amount testifying. Even it's not known how the source of this is material. It's not this is coming. This is different from the way your commission submits it, deciding what's happening to this convention. So I feel that this is a different trajectory that we should go through. It's that this is. And if you are denied access to clients, nothing will stop you from moving the course at any time so that we make that possible. But that line of submission, I will not have to explain.
Most of them.
I stand guided, Your Honor. Your Honor, I pray that the court takes judicial notice that the region of Shakahola has already been placed under curfew. Which is the alleged crime scene. And that, Your Honor, Shakahola is a region that does not specifically relate to where the respondents live or could have been living, or any of the respondents. It's a place like Mtwapa, like we would say Mtwapa, or would say Bamburi. The fear of interference with the alleged crimes has already been taken care of. Further, the supporting affidavit to this motion in all its paragraphs, it does not have any annexure as a piece of evidence that support the affirmance therein. It is based on mere affirmance and an intended route of investigation, which must not be the case. Your Honor, to say that the crime scene is within the property of the first respondent and the crime scene being a portion of land. There was need for evidence to show that he owns that particular area that is said that the dead bodies are exhumed or people were buried. That evidence has not been brought, despite the fact that he has been in custody. And they even conducted a search at his home. Those are issues that are to be handled in the hearing of the suit, in the event he is to be charged. Your Honor, the prosecution has submitted on the condition of the corpses information that suggests a post-mortem report should have been annexed, and which was not. I pray the court considers that all such averments and submissions by the prosecution and counsel for the victims, that they were evidence from the bar. Such averments were evidence from the bar, and there was no exhibit supporting that. And they seem to be disregarded. Your Honor, there are allegations that all the respondents are connected and that others were security. Such averments were made here. We pray the court to observe that each and every respondent has been brought here on his own personal account. And no evidence whatsoever has been tabled to link how they are connected, one to the other. All of them. There was no link whatsoever. Further, Your Honor, the first respondent has never been arrested anywhere outside the Malindi police station or the holding cells at the Malindi locals. The first respondent,
Yes.
his arrest emanated by him by a phone call. He was called by phone. Come to Malindi police station. And he went. Just a phone call. And he presented himself there. There was no effort whatsoever to say that he's at flight risk. His phones have been confiscated. That evidence is already with the prosecution in his call records. And that, Your Honor, when he was called, he was in company of the second and the third. And the fourth one, who joined him as a friend. And they were all arrested together. The rest, Your Honor, who are allegedly said to be security, offering security, it was not even defined what kind of security or how they participated, that the prosecution now forms the opinion that these are security guards. That evidence was not brought. We pray that you consider that there is no such evidence. Your Honor, an ID parade, if it is to be conducted, for the days that they were in detention, first 7 days and next 14 days, ID parade would have been done long time ago. And even if it is to be done in any date in the future, it does not require 90 days. You honor the allegations that there was an attack at the First Respondents Church. You honor the definition of a church by law does not meet what the prosecution wanted to insinuate to this court. There is no evidence to show that that is a church. A search was conducted in that place on 1st of May. On the 1st of May. And the deponent to this affidavit was present. Your Honor, I was also present together with my colleague by virtue of a court order requiring our attendance. And Your Honor, there was no church in that place. There was a building and a store. There is no evidence brought to you to show that the first respondent has a church. That evidence has not been brought. Your Honor, as to what the prosecution has stated they want to do in their further investigation, there is no link whatsoever that has been brought to show how that cannot be done when the respondents, when the individual respondents are out on bail or bond. There wasn't at all. But we pray the court to take note of that. They said that the victims are in a rescue center. This rescue center has not even been disclosed where it is, such as to say that they will interfere with the victims wherever they are. They have also stated that the respondents individually have been rejected by the community where they come from. Your Honor, those averments are not supported by any evidence. They're based on hearsay, among other averments. And more specifically, they did not specify each and every individual respondent where they come from, and who are the authorities or leaders in that community who have rejected them.